Constitutional law. The learning objectives of this section are as follows. First, we will define federalism. Next, we will explain how the U.S. government system of balance and checks operates. Third, we'll evaluate the effects of the Commerce Clause on the government's regulation of business. And finally, we'll recognize how the Bill of Rights protects the citizens of the United States. Let's talk about federalism. Federalism is a system of government in which the same territory is controlled by two or more levels of government. Generally, an overarching national government is responsible for broader governance over larger territorial areas, while smaller subdivisions, states, and cities govern issues of local concern. The key features of federalism are: 1, there are two or more levels of government. In the United States, we typically have 3. We have the federal government, we have state governments, and then we have city or local governments. 2, different tiers of government govern the same citizens, but each has its own jurisdiction in specific matters of legislation, taxation, and administration. And finally, probably most important, the jurisdictions are specified by the Constitution. How does federalism work for us in the United States? The United States Constitution is the document that set up our entire system of government. It tells us the distribution of power among the 3 branches of government and distributes power between the federal government and state governments. Additionally, it sets forth the rights and duties of the federal government, and it also sets forth the ways Americans are protected from the government. Now, this is really important. This is covered in the Bill of Rights. So let's go over the constitutional powers of the government. The first thing I want you to understand is that the federal Constitution was a political compromise between the advocates of state sovereignty and the advocates of a strong central government. One of the things that a lot of people sometimes forget is that the United States Constitution was not the first document that was drafted, right, to govern the United States. The first document that governed the United States was the Articles of Confederation. Now, unfortunately, or maybe fortunately, this document didn't last long because there were some inherent flaws with the distribution of powers between federal and state governments. One of the things that the Articles of Confederation did was it made state governments very, very strong and the national government very weak, right? Weak to the point where it did not have the authority to negotiate treaties between the United States and foreign countries. It did not have the authority to make coins. It did not have the authority to tax individuals, right? Basically, it was primarily just a treaty, right, for common defense, right? Because of those flaws, right, it was reworked, it was disbanded, and the Constitution was written. Now, one of the real big things that the Constitution does for us is it separates the powers of the government. The Constitution divided the government into 3 branches: the legislative branch, the executive branch, and the judicial branch. This was an important decision because it gave specific powers to each branch and set up something called checks and balances. And just like it sounds, the point of checks and balances was to make sure that no one branch was able to control too much power, right? So it separated the powers, right? Now, once again, the 3 primary branches are the legislative branch, that's Congress, the Senate, and the House of Representatives, the executive branch, and all cabinet level departments, and the judicial branch, right, which is all federal courts led by the Supreme Court. Now we're going to talk about checks and balances, and we're going to talk for a moment about the power that each branch has over every other branch. We're going to start off with the power of the legislative branch over the other two branches of government. Now, once again, as a reminder, the legislative branch consists of the United States Senate and the United States House of Representatives. Now, over the executive branch, the legislative branch can refuse to approve the president's budget. Right? One of the things that the Constitution gives to the legislative branch is control of the purse strings of this country. It is the legislative branch, not the executive branch, not the president, that creates our budget for each fiscal year. Second, the legislative branch can overrule presidential vetoes. Now, it is the responsibility of the legislative branch to create laws or legislation. However, what they present to the president is not a fully formed law, but a bill that the president signs into law. Now, there are times when the president does not agree with the potential laws that Congress wants to pass. So the president vetoes those bills put before his desk. Now, when a president vetoes a bill, he doesn't just say no, he says no with reasons. And as a general rule, what Congress does is they look at a presidential veto, they take into account the reasons why the president vetoed the bill, and they generally make changes to the bill to take into account the president's concerns, and then they represent it to the president, and generally the second, or even sometimes third time around, the president signs the bill into law. However, there are times when Congress is adamant about the bill that they drafted becoming a law. And in those occasions, by a majority, they can overrule a presidential veto. Right now, this is really, really important, because if the president had the sole authority to determine which bills became law, the president, in fact, would be the person that wrote the laws. But that's not the case. And once again, this one in particular prevents one person from becoming too powerful. Checks and balances. Number 3, the legislative branch can refuse to approve presidential appointees. Cabinet level officials and other key officials are appointed by the president with the consent of Congress. If Congress disagrees with the president's choices, they can say no, and then the president has to present someone that they find acceptable. 4, the legislative branch can refuse to ratify treaties. As the chief executive officer of the United States, the president is empowered to negotiate treaties on behalf of the country. But once again, checks and balances prevents the president from having the final say in whether a treaty is in fact ratified, right? Which simply means followed by the United States, right? That falls to the legislative branch. Now, in times of extreme need, extreme situations, the legislative branch can impeach and remove the president. Now, as a statement of fact, in the history of the United States, only 3 presidents have been impeached. President Johnson, who assumed office immediately following the assassination of Abraham Lincoln, Bill Clinton, and Donald Trump. All 3 presidents were in fact impeached. However, no president has ever been removed from office. Now, here's the thing. A lot of times people think that President Nixon was impeached. Impeachment proceedings were brought against President Nixon. However, before Congress had an opportunity to vote, the president resigned. So he was not impeached, he resigned. He was not removed from office, he resigned. Now, what power does the legislative branch have over the judicial branch? Well, the legislative branch can pass amendments that overrule judicial rulings. The legislative branch can impeach judges. Now, one of the things that is really important, in particular to our form of government, is that if you are a federal judge, you're appointed to that position for life. The idea being, if you have a lifetime appointment, you are above the law. And if you're above the law, you don't have to rule in any particular way to curry favor with voters to keep your job. The idea is that if they have a job for life, judges will rule in the best interest of the country, not the best interest of their constituents. And for the most part, this works fairly well. However, judges are people, and people are not perfect. And sometimes judges mess up. Sometimes they engage in behavior that is inappropriate, sometimes even illegal. And in those situations, judges can be removed through impeachment proceedings. The legislative branch is empowered to establish lower courts and determine how many judges we need in this country. What are the executive branch's powers? Now, once again, the executive branch is led by the President of the United States. Well, on the legislative branch, the executive branch, the President, can veto legislation, can veto laws brought to him as bills by the legislative branch. The President can call special sessions of Congress. Right? If Congress is not in session, the President can bring them into session if there's something urgent that needs to be discussed, that needs to be decided. Now, over the judicial branch, the President has the power to appoint federal judges. Now, this is really, really important. Why? Because people tend to appoint people who share their political views. Right? So the appointment of federal judges is something that presidents do that far exceed the terms of the president. Because once again, a judicial appointment is an appointment for life. And if a president appoints somebody who is in their 40s or even 50s, potentially their decisions can shape the course, can shape the courts, can shape our nation's laws for 30, 40, maybe even 50 years. Right? Just take a look at how old some of our judges are. Right? There's some people on the Supreme Court that are almost 90 years old. Right? And they've been judges for longer than most of us have been alive. Right? Real big power that we've seen our current president exercising in a very interesting manner is they can pardon federal offenders. Now, I want you to underline federal. Why? Because the President of the United States enforces federal laws, not state laws, right? So if someone's been convicted of a federal crime, the president can pardon that person. If someone's been convicted of a state crime, the president does not have that authority. A governor has the authority to pardon someone based on a state crime, but the president does not. Now let's talk about the judicial branch, the final branch of the big three. Now, they don't have as many powers over the other two branches as the other two branches have over each other, but the powers that they have are incredibly significant. Now, over the legislative branch, the judicial branch can declare laws passed by Congress to be unconstitutional. Now, if a law is unconstitutional, that means that that law is illegal and unenforceable. Over the executive branch, the power is very similar. It can declare the action or an action of the executive branch to be unconstitutional. And once again, if that action is declared to be unconstitutional, that action is illegal. As I'm sure everybody knows, the U.S. Constitution is the supreme law of the land. There's no law higher in the United States than the U.S. Constitution. Now, this comes from the Supremacy Clause, which is Article 6 in the Constitution. The Supremacy Clause states that federal law is the supreme law of the United States, and that any state or local law that directly conflicts with federal law is void. Another way of saying this is federal law trumps state law based on the Supremacy Clause in the Constitution. Now, one of the things that I want you to look at, it says any state or local law that directly conflicts with federal law would be void, right? So a lot of people assume this means that if the federal government chooses to legislate in any area, state laws are automatically void. That's not true. Any state law that's in the same area that the federal government is legislating is enforceable as long as it does not conflict with federal law. For example, and this is an example for educational purposes only, because we do not have a national speed limit. But if we did, and if the national speed limit was 70 miles an hour, New York could have a speed limit in the state of New York that's 65 miles an hour. Now, this is legislating in the same area, but it doesn't conflict with the federal regulation that says 70 miles an hour. It really strengthens the law. That would be okay. What would not be okay is if we had a federal speed limit of 70 miles an hour and New York State said the state speed limit was 80 miles an hour. That would be a conflict with the federal law, and it would be void. It would be illegal. It would be no law at all. Since we talked about the Supremacy Clause making the U.S. Constitution and federal law paramount in the United States, we have to talk about the part of the Constitution that has the greatest impact on business, and that would be the Commerce Clause. Article 1, Section 8 of the U.S. Constitution expressly grants Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Now, this language is a little bit archaic because we don't refer to Native Americans as Indians anymore, but this was how Native Americans were referred to when the Constitution was drafted. Now, the reason why the Commerce Clause is so critically important is because one of the other things that the Constitution does that I did not mention is it limits the power of the federal government. Any power not expressly granted to the federal government in the U.S. Constitution is reserved to the states. Now, before we had our Constitution, as I told you, we had the Articles of Confederation, and one of the things that the Articles of Confederation left open was who controlled commerce overall in the United States. Who controlled commerce overall in the United States. And because that was wide open in the Articles of Confederation, states would enter into deals that benefited the states but potentially hurt the country. For example, right, each state has something that it's better at than other states. It might be a crop, it might be an industry. Let's say Virginia, North Carolina, they're known for tobacco. Virginia and North Carolina entered into a trade deal with England to sell England to tobacco for money. That's good for Virginia, that's good for North Carolina, but it may not be so good for New York, it may not be so good for Florida, it may not be so good for Maine. But the national government couldn't do anything about it. Another thing, each state is like a mini country. And just like with a country, states depend on tax revenue to operate. That being the case, states are concerned with protecting local businesses. Now, at this point, I have to give you a couple terms that will make some sense, or that will help you make sense of what we're going to talk about. Right? The first term is domestic. A domestic business is a business located within the state. The next term is foreign. A foreign business is a business located in another state. The third term is alien. An alien business is a business located in another country. So domestic, within the state; foreign, in another state; alien, in another country. Two more terms: inter and intra. Inter and intra. Inter means within, intra means between. Inter means within, intra means between. Well, the Commerce Clause in this one statement highlighted in red grants Congress the power to regulate commerce, regulate business, with foreign nations. That means that states can no longer make treaties on their own. Only the federal government can make treaties with a foreign country, and among the several states. And this means that state governments can regulate intra-state commerce, commerce within the state, but only the federal government can regulate interstate commerce, commerce between the states. And that last part, and with the Indian tribes, well, Native Americans, their tribal lands, their reservations, are considered to be a nation within the nation. What does this mean exactly? It means that while they're physically in the United States, and a reservation may physically be in New York State, it's not part of New York State. It's part of the United States, but it's an independent entity within that state. So Native American reservations must follow federal law, but they're not required to follow state law based on the Commerce Clause. Now, as I said, this is the primary source for federal regulation over businesses. And as such, it has the greatest impact on business, far greater than any other constitutional provision. Now, one of the things that the Commerce Clause did for us, or not really for us, but for the federal government, is expanded national powers, or the powers of the federal government. Now, as I said, the Constitution is a limiting document, and any power not expressly granted to the federal government in the Constitution is reserved to the states. Well, here's the thing. The Constitution lets the federal government regulate commerce. Commerce is business. The question that I would have is, what is not business? What is not business? Because everything can be considered business. And potentially, however local something seems to be, it could ultimately have some impact on interstate commerce. The Commerce Clause does two things simultaneously. It expands the powers of the federal government with regard to interstate commerce and what falls under the banner of interstate commerce, and it restricts the power of state governments regarding intrastate commerce, right? Because specifically, what business activities are limited to impacting business in only one state. Now, from its beginning, the Commerce Clause has been used to expand the powers of the national government. First, it was relatively small, and over time, it encompasses pretty much everything. Now, where did it begin? It began with a case called Gibbons versus Ogden back in 1824. Gibbons was granted permission from Congress to operate a steamboat in New York. Ogden was granted a license by New York State to operate a steamboat in the same manner. Ogden filed a suit for an injunction to prevent Gibbons from operating his steamboats. The Court of Chancery granted the injunctions, and Gibbons appealed to the United States Supreme Court. The Supreme Court reversed the decision of the lower court, holding that Article 1, Section 8 of the Constitution grants Congress the power to regulate interstate commerce. Now, a little bit of background on this. Basically, they were both operating ferries going between New York and New Jersey, right, on the Hudson River. They were both operating ferries going between New York and New Jersey on the Hudson River. Gibbons was given his license by New York State. Ogden was given his license by the federal government, right? So the question was, who had the monopoly? Who had the monopoly? And that's what the whole issue was, right? So Chief Justice John Marshall saw the power to regulate as coexistent with the other delegated powers of Congress. He declared that this power, like all others vested in Congress, is complete in of itself and may be exercised to its utmost extent and acknowledges no limitations other than those prescribed by the Constitution. So if the Constitution grants them a power and does not expressly limit that power, there is no limit on the power. Now, the manner in which Congress decides to regulate commerce, Marshall said, is completely at the discretion of Congress, subject only to the political check of the voters. Meaning that if the constituents, the voters, don't agree with what the politicians are doing, they vote them out of office, right? So it gave them quite a bit of power. Now, commerce has been defined many ways over the years. First, it was considered to be the trafficking and trading of economic commodities. It then became the trafficking and trading of economic commodities and the modes of their transportation. Then it became the trafficking and trading of any kind of commodity and the mode of its transportation. Then it became the movement of anything or any person and its mode of transportation. Next, it became economic activity that substantially or casually impacts on the trafficking, trading, or transportation of commodities. And finally, our standard today is commerce is any human activity or other phenomenon that has any ultimate impact on activities in more than one state. And I want you to pay close attention to the language. Any human activity. Wow. Okay, I'm cool with that, right? It's something that a person does. But then it says, or any phenomenon. What is a phenomenon? That's anything at all that has any ultimate impact on activities in more than one state. So basically what this is saying is, it does not have to be a direct cause and effect link. It could be something that is 10 times removed, 20 times removed, 100 times removed from an action in one state. If it impacts on another state, the federal government can regulate it. Now, I know you're saying, well, how does that really affect commerce? How does it affect us? Well, basically what this law is saying is, if your grandmother has a garden in her backyard and she chooses to grow tomatoes for her personal consumption, the federal government could tell her that while she is allowed to grow those tomatoes, she could not eat those tomatoes because in eating the tomatoes she grew, she was not going to the supermarket to buy tomatoes that may have been grown in another state. So in growing and consuming her own tomatoes, she's impacting on activities in more than one state. That's basically what the Commerce Clause grants the federal government the power to do. Now, while this expansion of power is both impressive and frightening at the same time because it's potentially ripe with abuse, the power has been used for good. The commerce power has been invoked to expand federal criminal legislation, as well as to push major social reforms such as the Civil Rights Act of 1964. Now, it was first used in this manner in the heart of Atlanta Motel versus the United States case. Here's our case summary. A large motel in Atlanta refused to serve African Americans. Now, the Civil Rights Act of 1964 prohibits racial discrimination in places of public accommodation. Clearly, a motel is a place of public accommodation. The motel owner challenged the Civil Rights Act in federal court, and the government counterclaimed, seeking to enforce the act against the motel. Well, basically, the motel owner did not agree with the Civil Rights Act of 1964, right? He wanted to continue discriminating against African Americans, right? And he argued that the federal law did not apply to him because his business was completely local in nature. It was an Atlanta-based motel, and it was only operating in Atlanta, which is only in the state of Georgia. Now, the district court held that the Civil Rights Act was in fact constitutional and that the motel owner could not refuse to serve African American patrons. The Supreme Court affirmed the district court's decision and held that the Commerce Clause gave Congress the power to mandate that private businesses that serve the public cannot discriminate on the basis of race. Now, the way the Commerce Clause was brought into this case was very, very interesting, because while this hotel was operated solely in Atlanta, 70% of its business came from people who lived out of state. So the argument was made that because the money was earned in a different state than it was spent in, it was, in fact, interstate commerce. Now, there are a few limitations on the Commerce Clause. The case that comes to mind is U.S. versus Lopez in 1995. Now, this case takes place in Texas, and it's basically a states' rights argument, right? Once again, and I have to emphasize this, any power not expressly granted in the U.S. Constitution is reserved to the states. If the Constitution does not expressly give Congress the power to do something, Congress cannot. It belongs to the states. Now, in U.S. versus Lopez, a high school senior was convicted for bringing a gun to his school after Congress had made it a federal crime via the Gun-Free School Zone Act. Now, Mr. Lopez took a gun to school, a .30 caliber revolver, for sale. The gun was not loaded, and he had made the mistake of telling people he was selling his gun. And of course, when you tell one person, that person tells somebody else, and eventually the authorities hear about it. When he came into the school, he was confronted by security. He freely admitted he had a gun in one pocket, 5 rounds in another. The gun was not loaded because he was planning to sell the gun for $15. He was convicted of violating this act. The Fifth Circuit Court of Appeals reversed the conviction, finding that the federal law was unconstitutional. It was a violation of states' rights. The U.S. Supreme Court, in a 5-4 decision, agreed, and the court held that the law was an improper use of Congress's power under the Commerce Clause, finding that guns in school did not have a substantial effect on interstate commerce. And I want you to hold on to that word, substantial. In Lopez, Chief Justice William Rehnquist wound his way among the court's presidents to strike down a federal law that had criminalized the possession of a gun near a school. He declared that commerce power extends to 1. The use of channels in interstate commerce. 2. The regulation of instrumentalities of interstate commerce, persons or things in interstate commerce. 3. A local commercial activity having a substantial relationship to interstate commerce, and that means a direct relationship to interstate commerce. And he stated that possessing a gun in of itself was not a commercial activity, even though gun violence does affect commerce. Most importantly, he argued that the effective prong of the commerce power applied to activity that is a commercial activity. He insists that the rule of substantial effects must be observed, and that limits the Commerce Clause. If you cannot show a direct relationship to the activity and interstate commerce, the federal government cannot act. A local government can, but the federal government cannot act. Now, this brings us to a real big conflict that's brewing. The federal government has control over interstate commerce, but under its police powers, a state government has control over intra-state commerce, commerce within the borders of the state, right? And as we know, very few things are purely local in their impact. Now, the 10th Amendment to the Constitution reserves all powers to the states that have not been expressly delegated to the national government. Police power refers to the right of state governments to regulate private activities to protect or promote public order, health, safety, morals, and general welfare. An example of a state using its police powers will be our zoning regulations. A zoning regulation is a land use regulation. And with zoning laws, local governments tell the owners of property exactly how they can use their property. Now, what's the justification? Once again, to promote public order, health, safety, morals, and in some cases, just general welfare. Think about this. In New York City, for example, we have some areas that are zoned commercial use, right? This tends to be where we'll have some of our big box stores like Red Hook in Brooklyn, where we have the IKEA. Other areas are zoned residential, right? That tends to be the neighborhoods that people live in. Some buildings are zoned mixed use. You see this in a lot of apartment buildings. People live in the top floors, but you'll have a store or something on the ground floor. Then you have some other areas that are zoned industrial use, right? This is where you have your factories, your junkyards. Now, what's the justification for this? Public safety, public health. Now, where do the morals come in? Well, many years ago, you guys may not remember this, but when Rudolph Giuliani was mayor, he went on a campaign to change the zoning laws in the city for morals, right? Real big example, one of the real big targets was Times Square. You know, back in the day, Times Square was a den of wickedness. You had all these adult entertainment institutions, and, you know, quite frankly, that's all that was on 42nd Street, and it was not a place that you could take your family. So Giuliani pressured city council to change the zoning laws on the grounds of morals. And more to the point, the result was you could not have an adult entertainment operation within 500 feet of a residential area, within 500 feet of a school or a church, within 500 feet of each other, or within 500 feet of anywhere that children were likely to congregate. And that's pretty much everywhere, right? Now, what was the impact? 42nd Street has been cleaned up, and it's now a huge tourist attraction where people flock to as opposed to avoid, right? So that's an example of the morals part. Now, where does the conflict arise? The conflict arises because you have very few business activities that are purely local. Think about retailing in New York. Think about retailing in New Jersey, northern New Jersey. How many of us go to New Jersey to go shopping in the malls when it's time to buy clothes for school or something to go out with? Because first, they have bigger malls with better stores, right? And because the taxes are lower, right? So people who live in New York go shopping in New Jersey. Does that impact on businesses in New Jersey? Does that impact on businesses in New York? Yes, it does, right? So even though something is in New Jersey, it's purely local. Even though something is in New York, it's purely local, because people can move back and forth because of how close these two places are, right? It really is an impact. Now, where does this come in? It comes in under the dormant clause or the negative commerce clause. In American constitutional law, there's a legal doctrine that courts in the United States have inferred from the Commerce Clause, which is Article 1, Section 8 of the Constitution. The Dormant Clause is used to prohibit state regulation that discriminates against interstate or international commerce. Now, once again, the national government has the exclusive power to regulate interstate commerce. State governments only have a dormant negative power to regulate intra-state commerce, commerce within the states. So when you have a conflict between a state's police powers and the federal government's commerce clause authority, right, who balances that? It's the courts, right? The courts have to balance a conflict between a state's interests and a national interest. Real easy example I have also goes back to the Giuliani administration. You know, one of the things that a lot of people don't think about when they think about governing a city is waste management. That's a huge problem for any big city. New York is a huge city. Now, prior to Giuliani becoming mayor, we handled it fairly straightforward. All garbage was dumped in Staten Island. It was all dumped in Fishkills. When he was running for office, he campaigned out in Staten Island. He asked what the people wanted. They said they wanted New York City to stop dumping their garbage in Staten Island. He said, well, if you support me and I get elected, we will stop dumping our trash in Staten Island. Giuliani wins. And in a rare case, a politician keeps his promise. New York City stops dumping its waste in Staten Island. But the problem was, the waste was piling up. Where do you put it? Giuliani's first brilliant idea was the ocean. The ocean is big, there's lots of water, so he had all the garbage in New York City loaded up on barges. The barges were taken out to the ocean a couple miles out, and he just dumped the garbage in the ocean. We had a couple of big storms. Almost all of that garbage washed its way back up onto the beaches of New York City. It's about a 2-year period where you could not go to any beach in New York because all the waste was up on the beaches. So what does Giuliani do? He solicits bids from waste management companies located all over the United States and Canada. Winning bid comes from a company based in New Jersey. This Jersey-based company is awarded the contract to dispose of all of the trash from New York City. Everything's going good for New York City. And then Chrissy Todd Whitman, the then governor of New Jersey, finds out that New York City is dumping its garbage in New Jersey. So what does she do? She calls the state assembly into session and she has them pass a law prohibiting the disposal of trash produced outside of New Jersey in the state of New Jersey. Now, this law immediately made that contract that the Jersey-based company had with New York City illegal as per Jersey law. Now, one of the things that a lot of folks don't realize is Giuliani was at one time a very good lawyer. He's a former federal prosecutor. So what does he do? He sues Christie Todd Whitman, the governor of New Jersey, and the state of New Jersey in federal court, saying that the law that Jersey passed was illegal because it violated the Commerce Clause. New Jersey responded by saying it was within the state's police powers to pass this law, excuse me, to protect the health and safety of its citizens. The question is, who's right and who's wrong? Is New York right as per the Commerce Clause, or is New Jersey right as per the state's police powers? Now, when a state passes a law in violation of the Commerce Clause, under the authority of its police power, federal courts have to balance the interests of the state versus national interests. Which law will control? In order to do this, the court will always ask three questions. Question one, did the state have a vested interest? In this case, did New Jersey have a vested interest? The answer has to come back, yes, to protect the health and safety of its citizens. Question two, was there any means other than passing a law that could have been used to accomplish the state's goal? In this case, was there anything New Jersey could have done to protect its citizens from New York City trash short of passing a law? The answer, once again, comes back no. Number three, very important question. Was the law as passed sufficiently narrowly tailored? Now, this means, did it cover what the state intended it to cover and no more? Was the law too broad? Did it cover too much? This is where New Jersey messed up. The law New Jersey drafted said no trash produced outside of New Jersey could be disposed of in New Jersey. Now, on the surface, that seems like that's not such a bad thing to say, but in practice, potentially it could be. I don't know how many of you have driven up and down I-95 from Florida to New York, but if you had, coming back to New York City, because I've done it many times, I went to school in Washington, one of my favorite places to stop when I was driving back up was the Maryland House, and that's where I get my gas, that's where I get something to eat, go to the bathroom, and whatnot. But as a guy, I'm always in a hurry. So you go to the bathroom, you get your food, you get your gas, and you eat while you're driving, because that's a whole lot of fun for some reason. Now, one of the things that my drivers will know is New Jersey gas is cheaper than New York gas. So one of the things I used to like to do was drive my car until it was almost empty, and that usually took me to the last rest stop in New Jersey right before I came back to New York. And I would always fill my car up with that cheap Jersey gas before I came into the city. Now, being a guy wanting a clean car, if there was any trash in my car, anytime I stopped it, I threw the trash away. Now, the way this New Jersey law was written, because I bought my food in Maryland and I ate the food before I got to New Jersey, when I threw the garbage away in New Jersey at the gas station, the state police could have given me a ticket. Why? Because the law said no trash produced outside of New Jersey could be disposed of in New Jersey. Now, that's not what the state intended when they passed the law, but that would have been a practical application of the law. That was too much. So in this case, balancing the interests of the state with national interests, the courts required New Jersey to rewrite the law to say no hazardous waste produced outside of New Jersey could be disposed of in New Jersey. Now, what did this do? It allowed New York to have the contract with the Jersey-based company, and it also satisfied Jersey's stated goal, which was to protect the health and safety of its citizens. Because garbage is garbage, since they already had waste facilities there, regular garbage posed an insignificant additional health threat to the citizens. It's only industrial waste, medical waste, chemical waste that would have been dangerous. So that you couldn't do. And that's how the federal courts always resolve these issues. They have to do a balancing act, right? And these are the three questions that must always be asked and answered when coming up with a resolution. The Supremacy Clause. Article 6 of the Constitution provides that the Constitution, laws, and treaties of the United States are the supreme law of the land. Preemption is a doctrine under which certain federal laws preempt or take precedence over conflicting state or local laws. Now, once again, I want to call your attention to the word conflicting, right? If a state or local law conflicts with a federal law, the federal law remains enforceable. The federal law controls. This is the reason why in the states where marijuana has been legalized for recreational use, those marijuana-based businesses do not have bank accounts. They are cash-only businesses. Why? Because banks are subject to federal regulation, and while marijuana is legal in the state, it's still illegal in the United States. And anytime the federal government wanted to enforce federal laws, they could shut those businesses down and lock everybody up. Now, one of the reasons why the federal government is choosing not to enforce their marijuana laws is politics. There is so much tax revenue being generated by those marijuana-based businesses that it's more likely than not that it'll be legalized nationally eventually. Right? In the short term, it just hasn't come to pass yet. So right now, there's a moratorium on enforcing those federal laws, but the federal laws could come back at any time. Business and the Bill of Rights, the Bill of Rights, the Bill of Rights. The Bill of Rights are the first 10 amendments to the U.S. Constitution. Now, the First Amendment deals with freedom of religion, freedom of speech, freedom of association, and freedom of the press. The Second Amendment is the right to keep and bear arms. The Third Amendment prohibits the lodging of soldiers in any house without an owner's consent during peacetime. This one comes directly from the American Revolution, as do they all, right? And if you stop and think about freedom of religion, right? In England, you have the Church of England, right? That church was more important than all other churches. You have freedom of speech, meaning you have the right to criticize the government, right? Prior to the revolution, if you criticized the British government, you could go to jail. You have freedom of association. The English had laws in place where groups more than 3 could not meet. And, if you're trying to take a political action, you have to be able to talk to the masses. And freedom of the press, right? If the government is oppressing people, the press has to be free to report. Second Amendment, the right to keep and bear arms. What does that do with? The right to keep and bear arms to hold the government accountable, to protect yourself from oppressive government, right? This is old school stuff. Third Amendment prohibits the lodging of soldiers without the owner's consent. Once again, the British used to just, if you had a nice big house and a big farm, they would garrison their troops in your farm, in your house, eat your food, just take your stuff without compensation. The Fourth Amendment prohibits unreasonable searches and seizures, right? This is the requirement for a warrant that we have in this country. The Fifth Amendment gives you your rights to an indictment by a grand jury and protects you against self-incrimination. The Sixth Amendment gives you the right to a speedy and public trial. The Seventh Amendment the right to a trial by a jury in civil cases. The Eighth Amendment prohibits excessive bails and fines and cruel and unusual punishment. Now, the purpose of bail is that you can come out and work on your own defense. And if they set the bail too high, you can't come out and work on your own defense. That will impact on your ability to have a fair trial. Cruel and unusual punishment, well, what's considered cruel and unusual is based on societal norms, so they change over time. The Ninth Amendment establishes that people have rights in addition to those specified in the Constitution. Right? This is where all of our privacy rights tend to come from. There's no one in the Constitution that says you have the right to privacy, but it's inferred from the Ninth Amendment. And once again, the 10th Amendment establishes that any power not expressly granted to the federal government is reserved to the states. Limits on federal and state governmental actions. Now, originally, the Bill of Rights only applied to the federal government. It did not apply to the states. However, the Bill of Rights was incorporated and applied to the states as well. Right? And that just makes sense, because if you have the right to do certain things on a federal level, but you don't have the right to do these things on a state level, since we all live in states within the federal government, do you really have those rights? The answer would have been no. Now, most of the protections do apply to businesses, right? Why? Basically, there are three forms of business ownership: sole proprietorships, where the owner is the business; partnerships, where two or more people come together to form a business, and once again, the partners are the business is the partners; and corporations. And a corporation is an artificial person, right, with many of the rights of a natural person. A corporation is an artificial person because a corporation is not born to a woman. It's brought into being by the laws of whatever state it was incorporated in, right? But of the three forms of business, this is the only one that's an entity in of itself. A corporation is not the owners, and the owners are not the corporation. Why is this significant? Well, with the sole proprietorship or partnership, since the partners or the sole proprietor are the business and the business is the sole proprietor or the partners, they have this thing called unlimited liability. What does that mean? That means that if the business is sued, the sole proprietor or the partners are personally liable. Now, since a corporation is an entity separate from its owners, if the corporation is sued, the owners are not sued personally. And all they stand to lose is their interest in the corporation. So if they've invested $1,000 in the corporation, they might lose $1,000, but they wouldn't lose everything. Whereas a sole proprietor or partner, if they have $10,000 invested in their business, and it's a $500,000 lawsuit, they're going to lose the business, they're going to lose their house, they're going to lose their cars, they're going to lose everything, right? So all the rules apply to people, right? And if the business is the person, it applies to them. Most of the rules apply to corporations, artificial people. Now let's talk about freedom of speech, because this is one of the ones that impacts on businesses directly. The right to free speech is the basis of our democracy. Free speech also includes symbolic speech like flags, gestures, movements, and we've seen quite a bit of this over the summer, and articles of clothing. Right? All of these things are covered by the First Amendment. Now, falling into freedom of speech is political speech, right? Political speech, and that's, speech designed to talk about a political issue, a political candidate, a political party, right? And as an individual, you've always had the right to engage in political speech. But the question is, can corporations engage in political speech? Can they use the resources of their owners and put them behind something that maybe the owners don't agree with? The answer is yes. Political speech by corporations is protected in the First Amendment. This is why most corporations give campaign donations to politicians, so the politicians do what the businesses want. Now, what about commercial speech? Well, courts give substantial protection for commercial speech. What's commercial speech? It's advertising. Now, the limitations that you do have on commercial speech are subject to laws in addition to the Bill of Rights. Right? Freedom of speech means you are allowed to say pretty much anything you want. However, you are liable for false statements, right, with regard to other laws, right? It might be defamation. It might be invasion of privacy. It might violate the Consumer Bill of Rights, right? So you are allowed to say things, but there are consequences. Now, restrictions must, where there are some, implement a substantial government interest or directly advance an interest and go no further than necessary. Examples of that might be if you watch TV, if you still have a traditional TV, not internet where you're streaming everything, certain types of shows come on at certain times, and certain advertisements are appropriate during certain times of the day just based on who's watching TV, right? Usually, if children are around, the material is somewhat censored, right? You have to be mindful of what you're saying in front of children, because what you're allowed to say to adults could be considered to endanger the welfare of a minor, right? Consider for a second the old cigarettes ads with Joe Camel. Joe Camel was a cartoon figure. We had a real big situation with all of these young people smoking. Smoking is hazardous to your health, right? So laws were put in place where you cannot advertise potentially dangerous things to minors, right? And that was a whole limit, right? So you don't see these cartoon ads for cigarettes. You don't see cigarette ads in magazines and things that young people are likely to look at, whereas you might see them in things geared for adults. Now, what kind of speech is not protected? Obscenity, obscenity, obscenity. It's a crime to disseminate and possess obscene materials, including child pornography. Now, defining obscenity is really, really difficult, because, the question is, what is obscene? And that's based to community standards and personal standards. That's why pornography is legal, with the exception of child pornography, and the thing that makes it illegal is the age of the participant, right? Under a certain age, you don't have the ability to consent, right? If you have two adults, they have the ability to consent, right? And, once again, what's the line between obscenity, pornography, and art? Some people believe that nude paintings are art. Other people believe it's obscene, right? So it's really, really difficult. And I'm going to ask you this question. Define pornography. Most of us don't have a clear-cut definition for what it is, but we all know what it is when we see it, right? And that's why it's really, really difficult. Now, it's also difficult to prohibit the dissemination of obscenity and pornography online. Why? Who are the internet police? Who's monitoring these things, and do they impact directly on privacy rights that we have, right? So it's very, very difficult to enforce those things. Now, of course, virtual child pornography is a crime. It is a crime. It is a crime, right? And that's anything that uses computer-generated images, right? It's not actual people, right? It's computer-generated images. Also, in the First Amendment is freedom of religion. The government may not establish a religion or prohibit the free exercise of religion. The Establishment Clause prohibits the government from establishing a state-sponsored religion or passing laws that favor one religion over another. And it simply means the government must be neutral, right? If they do something for one religious group, they must do it for every other religious group. Now, what's the applicable standard? Federal state laws that do not promote or place significant burden on religion are constitutional, even if they have some impact on the religion. An example of this would be religious schools, in order to qualify for federal funds, must, in addition to their religious curriculum, teach a secular curriculum. If they choose not to teach the secular curriculum, they're not entitled to the funds, right? That does not place a significant burden on these schools because the purpose of the schools is education. Religious displays. Religious displays on public property can be legal, but they must pass constitutional muster by not violating the First Amendment's Establishment Clause, which requires government neutrality towards religion. In deciding whether or not a particular religious display violates the Establishment Clause, the courts look at two Supreme Court tests, the limit test and the endorsement test. The limit test poses three questions. Did the state actor have a secular purpose for posting the documents? 2, was the primary effect of the action to advance or promote religion? And 3, was there excessive entanglement between the government and religious activities? Well, if you look at most religious displays that are put in front of government buildings, a lot of times you see them during holiday times, and you'll probably notice that no longer do they say Merry Christmas, they say Happy Holidays. No longer do you just have the Christian symbology, you also have the Jewish symbology, right? Now the government has to meet all three prongs of the test to survive, or they can't put up the display. The Free Exercise Clause is a provision in the First Amendment that prohibits the government from interfering with people's religious practices or forms of worship. As a general rule, the government can't tell you what you must worship or how you have to worship. Right? You're free to worship any way you want. Now, with that said, employers must reasonably accommodate beliefs as long as an employee has sincerely held beliefs. Now, this is a can of worms because it is not for an employer to determine the sincerity of beliefs, right? If someone says they believe something, all an employer can do is say, okay. Now, the piece here about reasonable accommodation simply means you don't have to do anything excessive to accommodate somebody's religious beliefs, right? So from a practical standpoint, can employers require employees to conform their religious behavior? The answer is yes, if their failure to conform has a negative impact on the business, right? Real big example that I always like to use is holidays, right? Many religions have different holidays, and they have a different number of holidays. Now, if I'm a Christian and I own a business, I can say, well, I'm going to be closed on Christmas and Easter. Everybody's off. As an employer, I can pick the days that I'm going to close my business, right? So if everybody's off and these are paid holidays, no harm, no foul. If I say everybody who works for me gets 5 holidays, we're going to do this based on seniority. My most senior person picks his 5, and then we go down the line. If you come to me and you say, Mr. Clare, well, in my religion, we have 15 holidays, I will say, well, pick your favorite 5. Those are the ones that you get. As long as I'm consistent and I treat everybody exactly the same, I'm fine. Now, you also have some issues with religious attire. Can you require an employee to conform? The answer is yes, if there is a substantial reason, a clear reason for conforming, right? Real big example is the fire department. Are there any Hasidic Jewish firefighters? The answer is I have no idea, because generally you can identify Hasidic Jews based on their attire. The men have the beards. Now, one of the things you may have noticed is firefighters do not have beards. Why? Because they're required to shave, right? Is there a secular reason why they must shave? The answer is yes. Firefighters wear an oxygen mask, and in order for it to seal, you must have a close shaven face. If you have a beard, it will not seal. And if it doesn't seal when you go into a fire, right, you could be injured by smoke inhalation, and you as a firefighter would pose a danger to yourself and the citizens you're trying to protect. So the fire department could tell an Hasidic Jewish man, you are free to become a member of the fire department, but you must shave to meet department regulations. And there's no particular reason why that's necessary. That would be the case, right? If there is no reason for confirming or conforming, right, an employer cannot require it. Now, with regard to the free exercise clause, there is a public welfare exception, right? Now, if a religious practice works against public policy, like your religion is to sacrifice people, right? Because it's illegal for everyone, it would also be illegal for you in the practice of your religion. Now, this brings us to the due process and equal protection part of the Constitution, part of the Bill of Rights. Due process is the legal requirement that the state must respect all legal rights that are owed a person. Due process balances the power of the law of the land and protects the individual person from it. When a government harms a person without following the exact course of the law, this constitutes a due process violation, which offends the rule of law. Now, when we talk about due process, we have procedural due process and substantive due process. Procedural due process is a doctrine in the United States that requires the government to follow fair procedures before depriving a person of life, liberty, or property. Substantive due process focuses on the content or the legislation. What does the law actually say? If you think about a criminal proceeding, and we talk about due process, if a police officer does not physically see you commit a crime, in order to take you into custody, in order to search you, procedural due process requires that the police officer obtain two warrants, right? A warrant for your arrest, in which the police officer must state probable cause, right, before an impartial magistrate in order to get him to issue it. Now, probable cause is some articulable reason to believe that the person is guilty of committing the underlying offense. Second, to search you, the police are required to have a search warrant, which must specify on the face of the document exactly what they are searching for and the address that they're planning to search. Now, both of these things prevent people from being taken into custody just because, right? An articulable reason. Let's say you're going by Best Buy and you notice it was a 75-inch flat screen TV in the loading bay. There was nobody there, so you figured it was meant to be a gift for you. So you put it in the back of your truck and you drive off. Unbeknownst to you, there was a video camera that videotaped the entire incident. The police did not see you steal the TV. However, they have it on videotape. They also got your license plate, the video camera. So that will be probable cause for the arrest warrant. Right now, on the search warrant, they would specify that they were looking for a 75-inch flat screen TV at your address, and they'd write your address down. When they come into that house,
to serve the warrant to search the house, the only places they can look are places that you could hide a 75-inch flat screen TV. If they look anywhere else, they've exceeded the parameters of the warrant, and that evidence, if they find something else illegal, would be inadmissible. Right now, this is designed to protect you. Now, let's say they've arrested you, they search your house, they found the TV. They take you to the station. Before they can start to ask you any questions, what do they have to do? They have to read you your Miranda warning. Right? This is the Fifth Amendment. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford one, one will be appointed to you. Right? The police must let you know that you have the right not to tell on yourself before they can ask you any questions. Now, because it's a right, you can choose to exercise that right by saying, I want my lawyer. Or you can say, I've got nothing to hide. Let me tell you how it happened. You have the right to do that. Now, procedural law also says that if you choose to exercise your right to counsel, once that right has been invoked, you can't change your mind unless a lawyer's there, and they can't ask you any questions until they get a lawyer. So you get a lawyer, and while the lawyer sits next to you, you make your statement. They decide that they have enough to go forward, so they present their evidence to the district attorney. He thinks he has enough for an indictment. Can they just send you to jail? The answer is no. Right? First, you have to have an arraignment where you're notified of the charges brought against you. Then you're asked to plead guilty or not guilty. Right? If you say not guilty, you have the right to a trial before a jury of your peers. Right? This is all procedural law. Now, when we start talking about substantive due process, the content of the legislation, the content of the law, is what the law actually states. In this country, we follow the rule of law, which really means the punishment must fit the crime. Right? So what is considered to be illegal will be specified in writing that's understandable by a person of average intelligence. Right? That's the requirement to be enforceable. Now, the detailed description of what the crime is really, really important, because once again, the punishment must fit the crime. Now, the thing that makes due process and equal protection work so well is that these things are applied to all people, regardless of who they are. Same standard, same standard, same standard. Okay, here's a caveat. That's the way it's supposed to work, and most of the time it does. There are exceptions. Roger Stone. I'm moving on now. Equal Protection Clause is a clause from the text of the 14th Amendment to the United States Constitution. The clause took effect in 1868 and provides, nor shall any state deny to any person within its jurisdiction the equal protections of the law. A primary motivation for this clause was to validate the equality provisions contained in the Civil Rights Act of 1866, which guaranteed that all citizens would have a guaranteed right of equal protection under the law. Now, you notice these time periods. This is immediately following the Civil War. The government must treat similarly situated individuals or businesses in the same manner. Now, the court can apply three different tests. Strict scrutiny applies to fundamental rights. Intermediate scrutiny applies to discrimination based on gender or legitimacy. And the rational basis test focuses on economic rights. Okay, let's talk about strict scrutiny and fundamental rights. Strict scrutiny is part of the hierarchy of standards that courts use to determine which is weightier: a constitutional right or principle, or the government's interest against the observance of the principle. U.S. courts apply strict scrutiny in two contexts. One, when a fundamental constitutional right is infringed, particularly those found in the Bill of Rights and those the court has deemed a fundamental right protected by the Due Process Clause or the Liberty Clause of the 14th Amendment, or when a government action applies to a suspect classification such as race or national origin. To pass strict scrutiny, the law or policy must satisfy three tests. One, is necessary to a compelling state interest. Now, while courts have never clearly defined how to determine if an interest is compelling, the concept generally refers to something that is necessary or critical as opposed to something that is merely preferred. Examples include national security, preserving lives in a large number of individuals, and not violating explicit constitutional protections. A law is narrowly tailored to achieving this compelling goal. If the government action encompasses too much, meaning it's overbroad, or fails to address the essential aspects of the compelling interest, the rule is not considered narrowly tailored. And finally, the law uses the least restrictive means to achieve its purpose. A test will meet this even if there's another method that's equally least restrictive. Intermediate scrutiny is applied to cases involving discrimination based on gender or legitimacy. In order to overcome intermediate scrutiny, it must be shown that the law or policy being challenged furthers an important government interest by means that are substantially related to the interest. This approach is most often employed in reviewing limits on commercial speech, content-neutral regulations of speech, and actions discriminating on the basis of sex. Intermediate scrutiny may be contrasted with strict scrutiny, the higher standard of review that requires narrowly tailored or least restrictive means to further compelling government interests, and rational basis review, a lower standard of review that requires the law or policy to be rationally related to a legitimate government interest. Now, when we start talking about strict scrutiny, you have probably seen some jobs in the government that were once gender discriminating, meaning there were certain jobs that women could not have, particularly in the military. And one of the things that you'll notice is that all of these things, when challenged, go under constant review, right? There was a time when females were not allowed to participate in combat-oriented positions in the military, right? Because there was a perception that females who were weaker are not suited to that type of work, right? As society learns more, as changes are made, right, you'll notice these laws of challenge and changes come to the forefront. The rational basis test. In U.S. constitutional law, rational basis review is the normal standard of review that courts apply when considering constitutional questions, including due process or equal protection questions under the 5th or 14th Amendment. Courts applying rational basis seek to determine whether a law is rationally related to a legitimate government interest, whether real or hypothetical. The rational basis test prohibits the government from imposing restrictions on liberty that are irrational or arbitrary, or drawing distinctions between persons in a manner that serve no constitutionally legitimate end. Privacy rights. Constitutional protections on privacy rights, right, are found in the following cases. Griswold versus Connecticut found the right to personal privacy is implied in the Constitution, and it was expanded upon in Roe v. Wade, a woman's right to choose or to do what she wants with her body. Now, federal privacy legislation, right? You have the Freedom of Information Act, the Privacy Act, the Health Insurance Portability and Accountability Act, HIPAA, which protects your medical privacy, and the U.S. Patriot Act, which erodes many of your personal privacies. All right, this was passed in Congress in the wake of the terrorist attacks in 9/11 in 2001, and they're reauthorized twice. This concludes our constitutional law lecture.